Hi, everyone. Harry here to talk about a potentially important decision in Louisiana in which a district court judge has granted an injunction against a Department of Education final rule interpreting Title IX, Title IX being the whole chapter of the Civil Rights Act that regulates education and educational institutions that receive federal funds. And the new regulation is about gender identity. So it adds to the already protected list that adverse action against is tantamount to sex discrimination. It adds gender identity. So you can't discriminate in education against pregnancy, or you can't. This is the body of law that says women's sports have to be basically equal and the like. All right. So the Department of Education adds to the list gender identity, which essentially means, by its terms, it's a little broader, but the rubber hits the road here with trans students, and the regulation, in fact, specifies you have to use the pronouns that the students prefer. They have to be able to use the bathrooms that fit their gender identity. It essentially validates the gender identity choices of students and tells schools who receive federal money anyway that to go cut against that constitutes sex discrimination or discrimination on the basis of sex, which is outlawed, everybody agrees, in Title IX. Now, there's a huge Supreme Court opinion that casts a shadow here, and that's the case from 3 terms ago, Bostock, in which Justice Gorsuch authored an opinion saying in Title VII, which governs employment, sex discrimination would cover gender identity, just by, as he saw it, and a majority of the court, a sort of plain reading of sex, essentially, and equating it with gender. So that it's that decision that basically the judge in Louisiana, a Trump appointee who's made the news before for certain activist rulings, including during COVID, has flouted more or less. So he says, yes, Title VII means covers gender identity when it talks about no sex discrimination. Title IX, not so much, he says. And the essential reasoning is just that Gorsuch was wrong in Title VII. I mean, basically, the opinion here by Judge Terry Doughty just says that the plain meaning and also the original history, bringing in legislative history and the like, normally not something that conservative judges want to do, is that sex means gender, means discrimination based on, against boys or against girls. The enactment was created to apply to 2 sexes. I'll read from his opinion. Nothing that says it was meant to apply to anyone other than biological men or women. So the final rule just cuts against that. Now, of course, it sets up a direct conflict with the Bostock case, where the court has said something other. He tries gamely. Let me tell you exactly how he tries to get around Bostock. Yes, he says, the Supreme Court found that an employer violates Title VII by firing an individual for being homosexual or transgender because sex plays a necessary and role in that employment decision. That is the holding of Bostock. However, says Judge Doughty, applying it to Title IX is not that straightforward. First, the DOE is saying that Bostock only clarifies the law and doesn't change it. And the Supreme Court didn't say whether Bostock applied to other federal laws, but it would be passing strains. This is not another federal law. This is another chapter of the same federal law. You'd have to sort of do cartwheels and hand flips to without, at least in the absence of very strong legislative history, to explain why Congress in the same statute meant to construe the same term one way where it applies to education and another where it applies to employment. And then basically, then just says, gives the rest of the reasoning is essentially they got it wrong. We've got to interpret words consistent with the ordinary meaning at the time they enacted the statute. And at the time, that just include discrimination against biological males and females. And, so basically, it's saying, I disagree with Bostock. The court finds no support in either the ordinary meaning or the regulations that Bostock's interpretation of sex should apply to Title IX. And it would essentially reverse the entire premise of Title IX, as it would literally allow biological males to circumvent the purpose of allowing biological females to participate in sports that the females were unable to participate in prior to 1975. So you see the subtext here. It's the, swimmer at Penn, the trans athlete. And, many people have remarked this is not a straightforward area when a biological male becomes through surgery a female and then competes and typically clobbers by a lot competing the other women against whom she's competing. That's the poignancy or maybe unfairness of that's been pointed out by many. You work so hard for a 0.2 second advantage, and here comes a trans athlete and blows you out of the water, as it were. So that's the sort of maybe the main that, and as always, bathrooms and pronouns that underlie, that provide the context of the opinion. But basically, it's just saying Bostock said this, I don't agree, and so Title IX, it doesn't apply. It's not the last word for certain. There are, as Judge Dowdy noted, there are 6 other cases pending on this reg around the country. In fact, a noteworthy sort of secondary point to make here. Dowdy issues an injunction, but it applies only to a region in the Fifth Circuit. He notoriously in the COVID era had a controversial decision that he then just issued a nationwide injunction for, really bringing up the whole controversy for how a single district court judge can so alter the law by entering an injunction. But so the injunction applies, but only to that area. But to get the injunction, he had to basically rule that, the equities are with the plaintiffs and they have a very strong legal claim. It's a rare case in which an injunction is entered that a ruling on the merits doesn't follow in the same direction. Now, the injunction itself could be appealed under the injunction standard and then come back for the trial, or maybe it proceeds to trial. But we have a pretty good idea of where Dowdy is anyway. So this is setting up an issue to be worked out, at least at the courts of appeals and maybe the Supreme Court, as to whether sex discrimination in Title IX, like sex discrimination in Title VII, encompasses discrimination on the basis of gender identity, or essentially knowing disparate treatment of people based on their status as trans persons. So there you go for a kind of a cheeky and opinion that really is cutting against the grain of the Supreme Court, but part of a whole roiled social context that people agree, I think, are much more complicated. The equities are are more difficult to discern than in the simple question of what pronouns you call people. That is to say, the athletic, competition, including trans females who were born biological males. We haven't heard the last of it, but for now, at least in this section of the country around Louisiana, the Department of Education regulation is not in legal effect. More to come. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.